Don't Get Burned Like Uber webinar. And how timely is this discussion, as I pointed out in the emails this morning, with Uber's CEO stepping down late last night / early this morning. This topic is of utmost importance for every company, and today we have two of the best presenters to help us explore and think about how we might align our companies towards the future. Our first presenter is Shane M. Cahill, Senior Counsel with Long Levit, LLP. He is an accomplished and experienced trial lawyer who has represented employers at both the state and federal levels, and he works to defend employers both large and small. Good morning, Shane. It's a pleasure to have you with us this morning.
Good morning. Thank you. It's nice being here.
Our second presenter today is John Younger, CEO and Mojo Master at HireMojo. John's recognized as a pioneer in the recruiting industry, a former VP of HR at Bank of America, an innovator, and has been ranked number 42 on Inc. 500's fastest growing private companies in the United States. He's an avid rower and one of the most thoughtful and insightful people I've ever met. And I also happen to know that he's a little bit under the weather today, but I want to thank him also for joining us this morning. Good morning, John.
Thanks, Mark. Good morning.
And so before I turn it over to our two powerhouses of knowledge, some quick housekeeping items. We most definitely are planning on Q&A towards the end of the session, so if you have questions, please do feel free at any time to move over to the JY bubble on the right side of the screen, click on the three dots and choose chat and type in your questions, and John will get those and we'll line those up at the end of the session. Or alternatively, you can click the chat bubble at the top of the screen, and then where you see the @ symbol, click where it says all and choose John's name, and then you can type in your question there. We will strive to answer questions at the end of the webinar, and lastly, this session will be archived, as you heard a moment ago, and details of how you can access it for free will be sent to you via email for you to reference or pass along to friends and colleagues. With all of that out of the way, I'm looking forward to learning more, and we'll turn it over to Shane and John.
All right. Thanks, Mark. And this is like I said, a really timely topic. I think, Shane, you're living kind of in the middle of the battle, as it were. Why don't you tell us a little bit about what the people can expect to get out of today?
That's correct. So what we're hoping, or what we will accomplish here today, is to first kind of define what sexual harassment is, the different types of sexual harassment. We'll talk about the elements of a sexual harassment claim and kind of a more traditional claim, something we call quid pro quo harassment, or just hostile work environment harassment. We'll talk a little bit about who can be held liable for this, from the employer to supervisors to even individual employees who engage in misconduct. And we'll also talk about some what I would call non-traditional kinds of harassment, workplace misconduct that most employers might not think would happen or would not think would constitute harassment. And then towards the end of the seminar, we'll talk about some ways to try to prevent harassment, the different types of policies businesses should have in place to train employees, and ways to try to mitigate the kind of problems that companies like Uber are having right now. So that, I think, is the agenda for today. It's a bit ambitious, but I think we can get through it all.
Hey, Shane, have the definitions changed? I know there's been a lot of updates on various laws, but have the definitions themselves changed?
You know, the definitions haven't changed too much. You know, traditionally, courts used to define kind of two types of harassment. They had them boxed into two categories, one being quid pro quo, and that was traditionally viewed as demanding sexual favors for advancement. So kind of the basic concept was an unwanted sexual advance or some unwanted behavior of a sexual nature by a supervisor directed towards an employee, with the idea in mind that if you give in to my advances, you'll go farther in this business. And I think that might be what a lot of people think about as sexual harassment. The other kind of traditional type of harassment was the hostile work environment harassment, and that's a concept that's become a little more fluid in recent years, to the point where courts have started getting away from this two-category type of harassment. They still use these phrases, but now there's just a much broader view taken of what can constitute harassment. And hostile work environment harassment under both California law, which is the governing law is the Fair Employment and Housing Act, and under federal law, which is Title VII, it prohibits the creation of a hostile work environment. And that's basically defined as an environment where there's unwanted harassing conduct that's so severe or pervasive that it's literally changed the circumstances of the employee's work environment. It's changed the conditions of their employment, so to speak. And traditionally that was viewed as maybe vulgar comments directed at an employee, touching. We've got some examples here in this slide. Heavy breathing. I've handled one interesting case where a group was sitting in a meeting and one coworker was kind of coerced, so to speak, to sitting in a chair with another coworker, and then she started being harassed, and other employees were making fun of her and making comments, and this went on for months because she had to share this chair with one of her male coworkers, and that resulted in a harassment claim. So those are kind of the two boxes, but the category that's really evolved over time is the hostile work environment category, and that's probably what we'll spend quite a bit of time talking about today.
Thanks, Shane. What about like the social media posts and things? Does that technically qualify as part of the work environment?
It can, and this is an interesting area of the law that's also evolving. You know, on the one hand, there's laws in California that prohibit employers from taking adverse employment action against employees due to lawful conduct that they're engaged in after work. So, for example, if someone's on Facebook or other social media and making comments about females in general or males in general or other individuals, even if they're potentially employees, and all this is happening outside of the workplace, it's difficult for an employer to regulate that or discipline the employee for that. And if they do, they could be overstepping their bounds. However, if that outside activity is not generally protected by some constitutional basis, like someone's right to privacy, and it does start to impact the workplace because you have rumors starting to circulate or problems developing between employers, then that does start to cross the bounds. And employers can sit down with the employee engaged in the abusive social media conduct and have a talk with that person, tell them that it's affecting the workplace, the conduct should stop, and if it doesn't, it could lead to further disciplinary action. And in fact, if it starts to affect the workplace, I think employers have an obligation to say something. But that is an area of law that's developing. I just had a client call with a situation last week asking about that, and we had to counsel them through it. It was two employees were dating. It wasn't a supervisor-subordinate situation. They were coworkers. They worked in different divisions in the company. They went away on a weekend trip. Things got really bad. The male coworker started drinking too much, and they got in a fight, and the female coworker flew home early from the trip. And then things started up on social media, and the male coworker was out at the bar talking about her and other employees he didn't like. And it wasn't really creating a problem at work other than the fact that people were talking about it. Nobody said they felt offended. Nobody felt like their job was at risk. But we did counsel the employer to sit down with the employee who was creating the buzz in the workplace, so to speak, and on social media, and sit down and say, what you do on your own time is your business. However, now what you're doing on your time is starting to impact the work environment. People are talking, rumors are circulating. We'd ask you to just kind of keep that in mind going forward, and if it gets bad enough, this could lead to problems. So this is arising more and more, and that was just a call I got last week.
Got it. It also sounds like Uber and Fox News could be two terrific case studies at a future time for both of these, quid quo pro and hostile work environment. They've seemed to have really pushed the envelope on both of those from what I can tell.
Yeah, so I just gave anti-harassment and discrimination training at a doctor's office, which you'd be surprised how often harassment claims arise in the medical field, just given how learned these people are. And right before I went into that, I saw the article started coming down in late February of this year about the engineer at Uber, Susan Fowler, who had started a blog about the harassment that she had endured at Uber. And it was a really weird case that nobody, I think, really saw coming, where she said from the time she started working with the company, one of her managers told her that he was in an open relationship with his girlfriend and that they were looking for new sexual partners. Just completely inappropriate behavior in the workplace. Started sending her emails and instant messages. She, of course, took screenshots of these so that there was pretty much rock-solid proof that this was happening. If it had ended there, and she went to Uber management, and if they had taken the claim seriously and engaged in remedial conduct, this may not have gone as far as it did. But she was essentially ignored, and it came out that this manager was doing this to other people, but she was being told by Uber management that it was this guy's first offense, and it was just a blatant lie. So Uber's human resources department didn't take it seriously, didn't really conduct much of an investigation, and really let it go unchecked. Well, fast forward a couple months, and Uber, to their credit, did hire a very good firm. They hired Eric Holder's law firm to conduct a full investigation, and what that revealed was literally hundreds, I think close to somewhere around 200 instances of harassment, and something like in the neighborhood of 50 of those were egregious enough to be actionable. It ultimately, just a few weeks ago, led to mass firings, and then, yes, I just saw the news reports late last night that Uber's founder and CEO, Travis Kalanick, I think is his last name, had finally stepped down. So these claims, when they're not dealt with, can lead to obviously very serious and bad consequences for employers and businesses.
Yeah, I understand. And it also, I think it's just very much like Bill O'Reilly and Fox News, right? It really comes down to how quickly it's both known and acted upon by management. And that's because sexual harassment can happen, but it doesn't necessarily put the company at risk right out of the gate. Is that right?
Yeah, that's correct, and that leads to the question, and we'll get to this slide here in just a moment about unusual and shocking cases, but that does lead to the question of who is liable. In California and under federal law, generally if one coworker is harassing another coworker of equal level, the company itself is only going to be liable for that misconduct if it knew or should have known of the behavior, or if it didn't even have sexual harassment, anti-harassment policies in place. And so it's important for businesses to have an anti-harassment policy in place. And if they know about harassing behavior happening, that they take immediate steps to investigate it, document that investigation and take appropriate remedial action. Now, if the person engaged in the harassment is a supervisor, someone with significant authority over the person who's being harassed, then the company may be liable really no matter what it does. There's somewhat of a strict liability for the misconduct of supervisors. So it's all the more important to monitor supervisors' behaviors and really train them well on the company's anti-harassment policies and the do's and don'ts.
Shane, a quick question about documented policies. My understanding is that it's certainly best case to have clear documented anti-harassment policies. But in the worst case scenario with no policies, don't the laws still reign supreme?
Well, the laws do, and we've got a couple slides that a little bit later. But California law has generally required policies, and last year it was beefed up, so to speak, even further. And employers, really with more than 5 employees, are required to have a written anti-harassment policy in place that defines harassment, that describes what's prohibited, that sets forth a complaint process, and talks about how an investigation and remedial steps would be taken. So in California, employers with basically more than 5 employees have to have a written anti-harassment policy in place, or have to provide at a minimum brochures to employees that are available from the Department of Industrial Relations, or the Department of Fair Employment and Housing.
And where would one get? Is that something that you have to go to an attorney to get, or are there other places to get an appropriate harassment policy, anti-harassment policy?
You know, there are HR consulting companies out there. You know, with a policy as important as this, I would encourage someone to talk to an attorney to make sure that, you know, literally all the I's are dotted and all the T's are crossed. There are a few cases out there that suggest even if an employer would not normally be liable for harassment, say it's one coworker harassing another coworker, and the employer had no reason to know this was happening, there are cases out there that say an employee may still be able to assert a cause of action against the employer and hold them, the business, liable for failure to properly train employees and have anti-harassment policies in place. It wouldn't be at all a solid case, but it would be enough to bring the business in and cause some havoc and having to defend a lawsuit.
What about cases where they're non-employee harassers? I mean, you know, we all work with customers and partners and various other people on a daily basis. What if, you know, the UPS driver is the harasser? What happens then?
So California law, again, it was bolstered last year to address that specific situation. And employers are required to advise employees that that they don't have to stand for being harassed by third parties with whom they're forced to engage with on a day-to-day basis during their business. And employers do have to take reasonable steps to prevent and stop, I would say more stop, misbehavior that they're aware of. And now, obviously, that's a lot harder for a business to control because they're not employing these third-party contractors or the UPS driver, for example. But if they're aware of it and the employee complains and says, you know, I'm being harassed by this person on a day-to-day basis, he or she comes in and makes comments about my body or keeps asking me out on a date even though I've said no, then I would say it's incumbent on the employer to probably contact that person's business and say, this is happening, please don't send this person over anymore, or you need to talk to them and stop this type of conduct. So that, and if that's not happening, if an employer just ignores those complaints from an employee it could, again, lead to the creation of a hostile work environment. And if the business just ignores that and lets it persist, a company could definitely face liability for allowing that type of harassment to go unchecked.
Yeah, and two other things that I've seen as well on that non-employee harassment. One is to talk to the driver directly if you're comfortable doing so. Two is to have the deliveries to another person, not the person who's harassed. And then lastly, make sure it's documented, right? That's an important step.
Definitely. The documenting is important, and I think the other two suggestions you offered about how to deal with that are perfectly appropriate. I mean, there's no necessarily right answer as to how to stop it, but as long as it's lawful, of course. But the wrong answer is always doing nothing.
Right. And this goes to the consequences. So, Uber, Fox News, others, your company, and not yours, Shane's, but the participants' companies don't take appropriate action. What kind of consequences are they looking at?
For some businesses, they can be completely crippling. There's kind of a summary up on the screen now, and this is somewhat of a famous Bay Area case from the late 90s that had involved a major law firm, Baker McKenzie, where the business had a partner who for years was just engaged in all sorts of misconduct, and you can see it here on the screen, harassing associates, harassing secretaries, making comments, touching, pulling on bra straps, like kind of a juvenile delinquent. And the law firm just simply didn't act. And in part, the partner who was engaged in this misconduct was he was a lucrative partner, brought in a lot of business. The firm failed to really document what was happening, didn't really do much of an investigation. They had talks with this partner, but it was fairly anemic action. And the jury found for the plaintiff in that case, which was clear that was going to happen, and awarded against the law firm $6.9 million in punitive damages because it knew what was happening and just stopped it. And failed to stop it. Ultimately, the court reduced that award a little bit, but the total award was still over $4 million against the firm. And I've seen similar cases. We just handled a case involving a CEO of a company who had an employee who would come in the office and do nutrition training and kind of provide yoga, but this person was also providing the CEO with in-home service, and she alleged there was one incident where at home he had kind of made an unwanted sexual advance towards her and touched her inappropriately, just one incident, and she ended up bringing a lawsuit. His defense was that it was completely false, that she was lying, that she had started all these rumors and gossip about him in the business, and so that led him to make the decision to terminate her. And that case ended up settling for multiple hundreds of thousands of dollars, and it wasn't necessarily the misconduct that was the problem. It was that the person to whom the CEO basically took it upon himself to be the judge, jury, and executioner, so to speak. He was the one accused of harassment. He decided that it was a lie, and he did his own investigation, and he terminated her. I mean, the appropriate course would have been for him to say to, maybe the CFO of the company or bring in an outside law firm to say, she's making these accusations. They're false. Can you please investigate this and provide my company with advice on how to handle this? So even where it's disputed, the consequences can be very damaging if appropriate action isn't taken. And that's generally where we see the biggest problems, is just the lack of action. It's the cover-up is worse than the sin, so to speak.
So this was a case where there was only one instance, or at least one presumed instance, and the CEO was later found guilty by a jury. Is that?
No, that case ended up settling, and the reason that it settled, I mean, it was really what we call a he said, she said case. He had his story, she had her story. There were no witnesses, and had that been it, it would probably have been a case that the CEO and the company would have decided to vigorously defend. The problem came because he decided in his mind, because she was lying about the incident, he was going to just terminate her. So he didn't engage in the appropriate steps to investigate what was a complaint made against him to the company. And that was really the main problem. So that case ended up settling because there was a significant risk of liability. And a lot of these harassment cases do settle, especially the ones where someone high up in the company is accused of harassment. A lot of times the companies don't want this they don't want to air this kind of dirty laundry in a public forum.
So Shane, this brings up another really interesting perspective, which is, what if, and again, this is sort of worst case, the other direction, what if there's an employee who simply wants a settlement and fabricates it?
We've definitely dealt with that. Employees who might have a history of poor work performance, who the writing is on the wall, that they're going to be terminated or let go, and then suddenly there's a claim of harassment or misconduct. And even in those cases, it's still important to go through all the proper steps, do the investigation, reach findings, and even if those findings are this is a completely fabricated instance of harassment. Now, that employee might still be terminated because he or she is not performing properly, and that employee probably could even file a lawsuit. It doesn't take much to file a lawsuit. But that business is in a much better position than the business who simply says, we don't believe you, and we're doing nothing, and by the way, you're a horrible employee, you're fired. Because the business who did the investigation, they've got the file documented, they reached conclusions that this was fabrication, and so the defense of that claim would be much easier. And that would be a case, I would encourage the employer to take to trial, show the jury that this person was lying, that there was no evidence that this harassment happened, and defend that case vigorously.
Got it. It makes perfect sense. So the takeaway for me is that if there is a case and there's some uncertainty around it, get a third party to do an investigation.
Definitely. I mean, companies and businesses can do their own investigations. There's nothing wrong with that. But if there's, the investigation has to be prompt, it has to be impartial, and it has to be conducted by someone who's qualified to do the investigation. Now, if the business has a well-trained HR person who understands how the process is supposed to happen, understands that confidentiality to the extent it can be maintained is required, who understands that the process needs to be documented, if the business has someone who knows California law and what's required, it's perfectly appropriate for that person to conduct the investigation. If they don't, I would encourage them to hire a third person or a third party that does know, possibly an attorney or firm or an outside HR consulting business who's done these types of investigations before. And obviously you have to modulate the response to the issue. You don't want to spend tens of thousands of dollars conducting an Uber-type investigation if it's just one employee alleging one kind of minor incident of, maybe an incident of, hey, on one time my coworker said something that I found harassing or degrading. I mean, you need to measure your response, of course.
Right.
But in any serious situation, I would encourage a business to consult a third party who's familiar with how to do these investigations if the business itself does not have someone in place to do that already.
Got it. Well, let me pivot a little bit here, Shane, and I want to dig a little bit more into the love contracts and what they are and what they mean.
Sure. So it sounds like a weird thing. And what these are really are acknowledgments by employees that a consensual relationship is happening in the workplace. And, just given human nature, employers and businesses can't always stop consensual relationships from happening at work. If two people are attracted to each other and they start a relationship, that's just really, really hard to regulate and prevent. Now, businesses can have non-fraternization policies. Of course, they may or may not always work. Again, and we talked about this earlier, employers have to be a little careful about being too strict in prohibiting coworkers from dating, just because, again, businesses have to tread carefully when they're trying to stop or discipline employees for conduct that's otherwise lawful that occurs outside the workplace. Employers generally can have policies in place that preclude supervisors or managers from dating subordinates, and that's generally okay. And those policies, can state that if it happens, someone might be transferred to a different division or a different supervisor, or they may be terminated. I mean, I wouldn't encourage that as being the first step necessarily. But if the relationship happens and the employer is okay with it or can't stop it or can't control it, especially if, for example, it's dating between two coworkers, we've put together, and these are known, what we call love contracts or agreements, where both employees state in writing that they're engaged in a consensual relationship, that being part of that relationship is not a condition of their employment, it's not part of their job, they can end it at any time without suffering any kind of adverse consequences at work, that they won't engage in any kind of favoritism or public displays of affection at work, and you can kind of see here the list of things that these agreements state. And you get both employees to sign it. A lot of times we'll encourage the business to have an arbitration provision in there that if one employee accuses the other one during that course of that relationship of harassment, then everybody agrees to go to arbitration to resolve that dispute instead of having it aired publicly in court. And this happens more times than not. I mean, we've handled cases with some, again, going back to some physicians we've represented, where a physician was in a relationship with a nurse, and everything was fine. It was consensual. They dated for a long time, and then she finally broke it off, and the relationship went very bad to the extent that she accused him of stalking her, and even breaking into his house or her house and assaulting her, raping her. It became very ugly. He vehemently denied the allegations, but it was one of those things where if they had an acknowledgement, an agreement in place, maybe that case, instead of being filed in civil court, would have gone to arbitration. Maybe it just never would have got there if the employer was kind of monitoring what was happening. So this can happen, and if there are situations where you have employees engaged in that kind of engaged in a relationship, it may be worth considering having them acknowledge its consensual nature.
That makes perfect. In fact, I've seen where companies didn't have an allocation or a carve out for love contracts, and it pushed the relationships into a little secretive thing, which in some ways, from what you're saying, would potentially set the company up for a sexual harassment claim later, whereas a policy with a love contract option, anti-harassment, might have actually helped mitigate that, right? And is that something you'd write into a policy like this?
We could. We definitely could. That if there is a consensual relationship, please bring this forward to management's attention or to human resources attention. And that would probably be in what we call a typical non-fraternization policy.
But would you actually include a love contract as an addendum or something to it, or would you do that separately?
We could have that. I think that would be more appropriate to do separately. I don't know that businesses necessarily want to have that contract attached to a policy or available. I mean, I think the ground line approach is please don't engage in this behavior. However, we understand the realities of human nature. So if you do, please let us know so that we can discuss how to proceed. And just create kind of an open door policy like that, especially because the agreement might need to be specifically tailored for each person. I don't know that there's not necessarily one agreement we would use in every situation.
Understood. Yeah, I could see where if it's a supervisor versus a coworker versus somebody who's not even in the same department or division.
Correct.
Got it. Well, what about training? Where does training come into this?
So, as it states here on our slide, training is always a good idea. As we discussed earlier, California requires employers to have written policies. Those policies about harassment and what constitutes harassment, those policies need to be in a handbook or somewhere where they're distributed to employees. So that's part of what I would consider the training process, just informing the workforce. For businesses that have 50 or more employees, they have to go an extra step. It's not just enough to inform employees of the company's anti-harassment policies. The business actually has to do what's called interactive training with supervisors. And the training that's required, it has to be conducted, it's 2 hours of training at minimum every 2 years for supervising employees. And this would be, again, employees who have the power or authority to hire, transfer, promote, really make, disciplinary decisions or make decisions affecting other employees. And those supervisors need to be trained a minimum of 2 hours every 2 years, and it has to be training that not only is seminar-like, where they're told about what sexual harassment is, what the elements are, what type of conduct in the workplace is prohibited, and what might be okay, but they also have to participate in that training, maybe be given a test or presented with hypotheticals and asked to participate in a group discussion. So I've done this type of training. I do it regularly for businesses. I know there's consulting companies out there that do it as well. If an employer has someone who in the office that's a trained HR professional, they could probably do this themselves. But that's the type of training that is required for larger businesses in California. We always encourage businesses also to train just the workforce. And that's a little bit different, and it's more of a session about what constitutes harassment, explaining to employees that it's not okay to bully or harass coworkers, explaining to employees that if they engage in that type of misconduct, they themselves might be liable under the law, and really kind of also explaining the difficulties sometimes of proving up a harassment claim against a company. So we encourage that in addition to training of supervisors, and that's not required, but I think it sends a powerful statement to a workforce.
That's great. Thank you, Shane. So the takeaway I have is that you can't go wrong with training, and it's about sexual harassment training, but also just harassment training in general.
Correct. And there are obviously many, many different forms of harassment. California law prohibits harassment based on a variety of what we call protected characteristics, and it includes age, sex, gender, military status, race, obviously, I mean, there's a laundry list, genetic makeup or information. It's a laundry list that seems to grow every year. So employers, it's important to be aware that harassment doesn't just involve sexual harassment, and even sexual harassment doesn't necessarily have to be motivated by sexual desire. Something can constitute sexual harassment even if the harassing employee isn't romantically attracted to someone or doesn't want sexual favors.
Pictures on the wall, things like that. Right?
Exactly, having pictures on the wall, or there's cases where we had it's kind of what I call a boys' club case, where we had a one female employee working in a trucking company office with about 6 other male employees, and in the work environment, the slurs, female slurs, were just prevalent. It was made on a constant basis. Bitch being the least offending of the phrases, unfortunately, that was used. And there were pictures up on the males' computers, and the female employee that worked there, she was never directed. None of this was ever directed towards her. However, it was so bad in the work environment that it became pervasive enough, and it affected her job enough that it gave rise to a sexual harassment claim that the court said would be permitted to go forward. So even when the conduct is not directed at an employee, it can be harassing. So employers should, when they see that type of misbehavior, address it. Talk to the employee, say, please stop that, or you must stop that. It's inappropriate.
Got it. Well, this brings us to the end of the presentation part of this. Let me do a quick about each company and then open it up to questions. So in terms of HireMojo, so HireMojo is a hiring automation platform, and it's basically a recruiter bot, something that does a lot of the work that recruiters do manually so that the recruiters can focus on the higher level stuff. And it includes all of the paid distribution sites and social networking, marketing, all baked in. We buy in bulk and just bake it all in. So that's what we do. Makes hiring just easier, and it learns with every new job so that there's a lot of predictive analytics rather than just trying to guess at how you should describe it or where you should put it. And Shane.
Yes, so Long Levit's been we've been in practice as a law firm since 1927. We're definitely a well-established San Francisco firm. We've been defending employers and businesses and professionals in trial. Since then, we've tried we try cases all the time. We're well versed with the courts through the Bay Area and Southern California. Throughout California, we're very experienced in the courtroom, as well as in counseling employees to stay out of the courtroom. And that's what I do in particular. So we're happy to provide assistance.
So I have a question here. The first question, it says, we'll just take a couple questions here. I am a female, and my boss continually yells at me, is late to meetings, provides no follow-through, demands too much work, and is unreasonable. Is this considered harassment?
One thing that courts are careful to point out is that the laws prohibiting harassment do not amount to a workplace, what they call a workplace civility code. That is, coworkers and even bosses don't have to be nice, and the courts won't regulate that type of behavior. If a boss is too demanding, is late or inconsiderate, is doing the things that's described, if that's not based on or because of someone's sex or because of someone's race or because of one of these protected characteristics, it's probably not going to amount to harassment. Now, California has evolved a little bit. And last year, what it required for larger employers was that there be training on what's called abusive conduct. And that kind of amounts to bullying and this maybe this type of misbehavior. So businesses with 50 or more employees have to train their supervisors and managers on what amounts to abusive conduct, and that it shouldn't be happening in the workplace. But California, and I could see this happening, to date has not gone the extra step of making that a viable cause of action. And I don't know that they will, because then you just start getting into the sticky situation of regulating human personalities and behavior. And I don't know that any legislature is going to go there or that a court would find such laws to be constitutional. So if it's just the boss being mean, that's one thing. If it's being mean because you rejected a sexual advance, that's a whole different story. And what you're describing or what this person's describing might amount to retaliation. But without that first step, it sounds like something like that would just be abusive conduct that, while unpleasant and maybe socially improper, isn't necessarily illegal or actionable.
Got it. I have another question for you, which is, can the individual harasser also be sued, or is it just the company?
Absolutely. The individual harasser can be sued. They generally are, in my experience, named in complaints. And that is somewhat unique under anti-harassment and discrimination laws. A lot of time, in discrimination claims, for example, and retaliation claims, where someone claims they're being treated differently because of race or gender or age or sex, the individual that's alleged to have engaged in that behavior is generally not liable. They can't be named. Only the business can be named for discrimination. Harassment cases, however, are different, and the individual, be it a supervisor, a boss, or even just a low-level employee, I mean, it could be a minimum wage employee, that person could be sued for harassment. They could be liable for it. I mean, it gives the question after that is whether that person could ever satisfy any kind of real settlement or judgment if they were found guilty of harassment. But yes, individuals can be sued for harassment.
Got it. So do companies have any recourse to file a counter claim or counter sue someone who begins a false claim?
The company itself, probably not. And it would just strategically would likely be a misguided approach. However, if it is an individual being accused and sued for harassment, there might be a basis for a defamation claim, but only if there were statements made through the workplace that were obviously untruthful and probably made with some malicious intent, that someone engaged in alleged unlawful harassment when it was untrue. If the allegation is just made in connection with a lawsuit, that would be what's called protected litigation activity, and you can't sue someone for defamation because they've made allegations in a complaint. You could possibly pursue them for malicious prosecution if the employer ultimately prevailed on the claims and it was found that the person had filed a frivolous lawsuit. But outside of those really limited circumstances, there's not much basis for attacking an employee in courts who have filed a sexual harassment case, even if it's without merit. You'd have to really go the extra step of showing that it was just a false claim and that the business prevailed.
Got it. And I have one last question, which is, if a company has a love contract, and let's say there's a couple that are making other employees uncomfortable because of their lovey-dovey behavior, but they refuse to sign the love contract, what is the path forward in that scenario? So the scenario is couple is very close to each other employees are uncomfortable with it, and the couple refuses to sign the love contract.
I would say probably the first step would be to talk to this couple and explain that they need to stop engaging in, romantic behavior in the office. If it's manifesting itself in other ways, like they're making little love jokes or batting eyes at each other, or giving each other certain or granting favoritism to one another over other coworkers. I mean, I think the first step would be to address that. You can't make the employees sign a love contract, and especially if they're coworkers. Again, it's hard to discipline them for the simple fact that they're dating. But you can discipline them for misconduct at work, and if they're engaged in inappropriate romantic behavior at work, that starts to rise to the level of misconduct that you'd want to address through counseling and discussions, asking them to stop that behavior, and if it continues, maybe separating those employees, if that's possible, putting them in different divisions, making them work in different spots, and if it still goes on, maybe transferring one to a different division, and if it still goes on, maybe rising to the level of terminating one of or both of the employees. But I wouldn't say that is the initial first step, get rid of them. I would say you kind of got to address it progressively, explain to them that they need to change and correct their behavior, and if it continues, you just take it the next step. But forcing them to sign a contract could be sticky. You could try it. If you terminate them for not signing the contract, they might bring a claim that their privacy has been invaded. So I wouldn't counsel that as being the first step.
Got it. Shane, thank you for sharing your depth of experience and wisdom today. I know I learned some things, and this is such an interesting, charged topic, and your insights are terrific. So this is being recorded. We will make it available for future reference for anyone who chooses to do that. And again, thank you, Shane.
It was my pleasure. Thank you for having me.
All right. Take care.
Yep, you too.
Thank you all, everyone. That concludes our webinar for today. There was some amazing insight there, and appreciate everyone taking the time to be here with us today. As John mentioned, in a few days you'll receive an email with a link to the archive version of this webinar, so be sure to watch for that. On behalf of Shane, John, and the entire HireMojo team, thank you for joining us, and have a great rest of your week.